It's a warm summer evening, but an unexpected thunderstorm has just rolled through the city. The remnants of clouds can be seen off in the distance. You are in your driveway, working on a neighbor's car. From the corner of your eye, you see a fully uniformed police officer crossing the yard, heading in your direction. As you glance at him, he booms out and asks, "Do you live in apartment 14?" He then asks for your name. Without thinking, you hesitate, but say, "Glenn." The cop gives you a quizzical stare and asks you if you are carrying ID and says he would like to see it. You briefly wonder what this is all about, and though you remain calm, you are a little irritated. Now, here is the question. Are you required to show a cop your ID upon demand? Welcome to the Four Eyes of Law. I'm attorney Larry J. Brookens, a California trial attorney with over 25 years of litigation experience in both the state and U.S. federal courts. As a lawyer, we must give our mandatory disclaimer. This video is for educational purposes only. It's not intended to provide specific legal advice about any specific case or person, or to establish an attorney-client relationship. As always, our first line of advice if you're facing a serious legal matter is to consult with an attorney of your choice. See our full disclaimer in the description. Before we bite down, please hit the subscribe button so you will receive our new videos as they drop. Avoid having to search the web when you need this information. Now, as the officer approaches, you intuitively know there is the potential for a situation. And as we always say, you are on the clock. What happens in the next few moments can decide whether the encounter ends quickly or turns into something nasty. Today, I'm going to explain what the current law is regarding this situation on a national level and in California. The question is, when can a cop make you identify yourself? And when can you refuse? We will be referring to a few controlling Supreme Court decisions that control this situation. Generally, a person is only required to ID themselves upon request of a police officer in a few narrow circumstances. These situations tend to fall into three categories. First, ordinary encounters with pedestrians, where there is no automatic duty to show an ID. Second, when a statute in a particular state require a person to identify themselves during a lawful detention. Third, when a person is driving. Let's look at the situation involving an ordinary pedestrian walking in a public place. Some states have what are called stop and identify statutes. Those laws require you to identify yourself during a lawful investigative detention. In 2004, the Supreme Court addressed this issue in the case of Hybel versus the 6th Judicial District Court of Nevada. After contentious argument by both sides, the Supreme Court ultimately ruled that, in certain circumstances, a state may require a person detained by law enforcement to give the officers their name. However, the police must have a reasonable suspicion that the detainee might be involved in a crime. Note, the court did not say officers can stop you for any old reason or for some silly nonsense and ask for ID. There is a condition. The condition is the officer must have a reasonable suspicion, based on specific articulable facts. The individual was involved in criminal activity. Here, law enforcement must have certain specific facts they can articulate, which suggests that a person may have been involved in criminal behavior. The leading case is Terry versus Ohio and was decided in 1968. In that case, the Supreme Court went on to explain that for officer safety, a cop may also perform a limited pat-down for weapons if it is based on reasonable suspicion. This is generally the law in California. Also, California does not have a stop and identify statute. Our next area concerning demands for ID occur when someone is driving. Here, the rules change entirely. When someone is stopped while driving, every state requires them to produce their driver's license, vehicle registration, and proof of insurance when asked by an officer. The primary reason the law does not allow a driver to refuse is because driving is considered to be a privilege and not a constitutional right. When a state gives you this privilege, it's based on your promise to follow its rules. One of those rules is to show your driver's license if asked by law enforcement. If your car stalls on a ramp or you are pulled over for a traffic citation, the easiest way to resolve the stop is to hand over those documents if the officer asks. Always do it slowly, with your hands visible and your movements announced. However, different rules apply to passengers. In many states, passengers do not have an automatic duty to produce identification just because an officer wants to see it. In those situations, officers must have independent facts that create reasonable suspicion of criminal activity or legitimate officer safety concern before demanding ID from a passenger. If an officer can point to such facts, a brief detention may be lawful. We have talked about brief stops and detentions so far, but what about arrests? You need to know that actual arrests and brief detentions are not the same. There are huge differences between the two. Arrests may entail booking procedures, fingerprinting, booking photos, extended questioning, and more formal obligations between suspects and cops. Questioning after an arrest may also trigger the need for additional protections in the form of Miranda warnings. The United States Supreme Court in 1966 explained in the case of Miranda v. Arizona that police must advise a person of certain constitutional privileges, including their right to remain silent and right to an attorney before they can conduct a custodial questioning or interrogation. Before we go further and talk about specific ways to handle police encounters, there are several key points to keep in mind. 1. It's important to know that the street or scene is not the place to challenge a stop, detention, or arrest. The proper forum to do battle is the courtroom, with a good lawyer at your side. 2. Know the laws of the state where the encounter occurred. 3. A person's tone, mannerisms, and emotional behavior can play a critical role in these situations. Now, if you decide to speak with an officer while detained, stay calm and respectful. Use short, clear sentences that preserve your legal position. Do not volunteer information. Let's look at an example. You're pulled over while driving in your Beamer on Manchester Boulevard in Inglewood. The cop asks for your license. Simply say, "Okay, it's in my center console," or wherever it is located. "Can I get it for you?" If he says yes, say, "I am going to open my console to get my wallet and give you my license." Once you have the license in hand, give it to them. Try to keep your hands visible while retrieving it, and do not engage in any sudden movements or jerky reactions. Announce each movement you are going to make before you do it. The next example occurs while you're walking past Crypto.com Arena across from LA Live. The goal is to maintain a calm scene without allowing it to escalate. If you want to know the status of your stop, respectfully ask the officer if you are being detained or free to leave. That question helps to establish whether the encounter is consensual, a detention, or an arrest. Since many police departments require officers to wear body cameras, this may help to preserve evidence if you must go to court later. If you are detained in a state like California, which does not have a stop and identify law, and prefer not to speak, consider respectfully saying, "I'd prefer to remain silent and would like to have a lawyer before answering any questions." Then, remain silent. If you are stopped in a state that requires identification during detention, simply provide your identity and stop talking if you prefer. A refusal may result in a separate citation or arrest, apart from the reason the stop was based upon. Another important point to remember is that, regardless of what state the incident occurs, the scene is not the place to resist or challenge the cop's legality. The place to challenge the lawfulness of a stop and ID demand is later, in a courtroom. Again, driving is an entirely different beast. Drivers must provide their license ID, registration, and proof of insurance when requested by an officer. A refusal often leads to a citation, arrest, and other severe legal consequences. If you find this information helpful, please pay it forward by hitting both the like and subscribe buttons. This helps this channel to continue to provide informational videos to people who need it. Also, you will receive our new videos the moment they drop. Avoid having to search all over the web. Leave a comment below and let us know if you have ever witnessed any unusual police stops or detentions. Thanks, and stay safe.